Hi everyone. So I decided to do this shorter video, which would just be reading the motion. I am joined by my dog Mia today, so if she makes a noise, I do apologise for that. So here is the motion. At the top, it's got all the pertinent information, my name, the case numbers, who the parties are, and which subpoena I'm moving to quash, and who served it to me, which is obviously Ezra Hudson. So it says, please take notice that non-party movement Leanne Newton hereby moves this court to accept this pro se motion to quash pursuant to Federal Rules of Civil Procedure 45D3 and 45C2 to quash or revoke the subpoena issued to X-Corp dated 3rd July 2025, seeking personally identifiable information and private data associated with my X account, KRJ2001, or YouTube channel Leanne Newton 1572. Ezra Hudson, counsel for the party who served this subpoena, has erroneously misspelled the username Kiara Jade 200, omitting the number 1 at the end. For clarity, the account Kiara Jade 200 does not exist, but when it is searched for, the only account suggested is mine. And I will show all the exhibits at the end, but there was a footnote in there as well, and that says courts, both in the UK and in the US, and in the US I do cite Rule 45 substantial compliance test, have consistently held that a spelling error does not invalidate a subpoena where it is obvious who the subpoena refers to. The chance that there is another X account with an almost identical username who is also covered in this case is incredibly small. Furthermore, another person on the subpoena list contacted me to notify me that they recognized the name which they believed to be mine. Ms. Hudson has not responded to my email requesting clarification, so out of an abundance of caution, I am responding to ensure I do not miss any deadlines. Now, at the time I read this last night on the live stream, Ezra Hudson's office had actually emailed me back and confirmed that it was mine. And they have, since they've received the motion, because I had to serve it upon them, they have reached out to try and arrange a meeting with her. So there is all that going on. So I am filing this motion pro se to ensure that there is a response from myself on file before the deadline. We have been advised of 31st of July 2025. I have very little information regarding the subpoena. Some accounts have not yet received a copy, even at this late stage, including myself. Ms. Hudson thus far has failed to return my telephone calls or respond to my emails. I have found her office to be evasive and uncooperative in addressing my concerns and questions, an issue which other subpoena non-parties have also experienced. Even when subpoenaed non-parties have demonstrated the difficulties they have experienced, the interaction has been misrepresented to the court. So here I'm referring to the letter where she referenced Andy from Popcorn Planet's recording of a phone call. Ms. Hudson filed a letter to the court stating one subpoenaed content creator even went so far as to record a call with the receptionist from Miss Lively's attorney's office without express consent, and then posted the recording on YouTube. Ms. Hudson then proceeded to include a link to the content creator's show where he was recording his call with a receptionist from her law firm. The video very clearly showed that the content creator had notified the receptionist that the call was being recorded at the start of it, and the receptionist had chosen to continue the call under those circumstances. She then suggested in a footnote that the content creator had committed a crime, which is not true. And I do actually cite law there, the case of Kearney versus Solomon Smith Barney Incorporated. That was a decision from the California Supreme Court. So that basically said that even if you don't affirmatively consent to having your conversation recorded, if you are informed at the start of the phone call that the call is being recorded, the recording would not violate the applicable California statute. The response in the X-Corp subpoena is due on July 16, 2025. However, notice was not sent until 17th July 2025. I'm aware that the deadline for compliance with the Google subpoenas has been extended to the 31st of July, and assume that courtesy has been also extended to include X-Corp. I'm concerned that tactics may have been employed to cause confusion and or delay so that I will miss my chance to file on time, given the treatment of another non-party subpoena that was not issued as part of this lawsuit, but has material relevance to it. And here I'm referring to Van Zandt. So the footnote actually does give the details of the Van Zandt lawsuit, the index numbers and everything that go with it, so the judge can see that. As I'm a British citizen and resident, I will be making my arguments based on both British law and American laws to ensure that all potential bases are covered. So my introduction. This motion to quash refers to a subpoena served on X-Corp, which is seeking the private and personal information of 20 X creators under the premise that we are engaged in a smear campaign against plaintiff Blake Lively. The subpoena is unsupported by any evidence of good faith basis, and not a single solitary offer of proof exists to insinuate any connection between the subpoenaed content creators and any party who is the subject of the underlying case. Further, such inquiries should be made directly to the parties of the underlying case to obtain connections to third parties. It is monstrously inefficient to seek connections to the Wayfarer parties through selecting third parties at random for what amounts to a digital strip search. It also has the chilling effect of freedom of speech and expression, both of which are protected under the Constitution of the United States of America. If that wasn't already enough, I believe that a request of this nature compromises the safety and privacy of non-parties who never intended or foresaw that they would be pulled into this litigation. I create content on various social media platforms, and I report on the publicly available legal filings in this case, and the various related lawsuits and motions filed across multiple jurisdictions. In many of my YouTube videos, I have openly shared my own experience of domestic abuse and the years-long criminal proceedings that followed, along with the effect of all of that on my family and myself. Like many others, I was hopeful of the positive impact that the movie It Ends With Us would have on bringing awareness to the serious issues of domestic abuse and sexual violence, and aid women to recognize the signs of an abusive relationship. I hoped that the partnership with a charity, such as No More, would provide desperately needed resources to anyone who is seeking help and advice. I had seen Justin Baldoni's previous work, which had centered on sensitive topics, including cystic fibrosis, and I was optimistic that he would do justice to the subject matter of the film. And I have put links there to the webpage, which showcases the partnership between the film and No More. When the promotion was underway, it was clear that it was lacking any messaging about domestic violence. Mr. Baldoni was the only member of the cast who was vocal about domestic violence, and in fact, on the occasions Mr. Lively was asked a question about domestic abuse or how people could share their experiences with her, she scoffed, laughed, and answered with an inappropriate joke. And I put a reference to that video. Not a reference, sorry, a link. The rest of the promotion fared no better, with cross promotions of hair care products and alcohol, which was completely at odds with the intended supportive messaging around domestic violence, and not name-dropping her famous friends, along with their clothing brands and songs. And I do reference there the document on the docket, Wayfarer's First Amended, where that text message where she was claiming to be Khaleesi and had dragons. That's what I'm referencing there. There was further controversy when Brandon Sklenar filmed a junket with Ryan Reynolds, who portrayed a jealous husband, Hugh Jackman, who portrayed a jealous best friend, and Mr. Reynolds' mother portraying a jealous mother-in-law, whilst simultaneously fixating on a close-up image of Mr. Sklenar's clothed posterior. And there's a link to that video as well. Like many people, I was horrified that not only was the important message intended to raise awareness of domestic abuse being erased, but that the people in charge of the marketing, which is obviously maximum effort, and promotion, were mocking it and even imitating some of the behaviours that are commonly associated with domestic abuse. Then we were all told to grab your friends and wear your florals when we go to see the movie. Miss Lively also claimed that the movie is not about domestic violence, even though the book's author, Colleen Hoover, has expressly stated that it was written based on the abuse her own mother had endured. And there are links to all of those quotes from Blake Lively. It became evident that Miss Lively and Mr. Reynolds had hijacked the movie promotion that was intended to benefit vulnerable people and used it to promote themselves and their businesses, whilst excluding the one person who was sticking to the intended message. And they appeared to be confused as to why it did not make them look good. Miss Lively, who still cannot accept the criticism against her online was entirely organic and of her own making, has made yet another move guaranteed to make matters far worse for her reputation by lashing out at content creators on social media. She appears to have failed sufficiently to prove her case of retaliation, and with deadlines for discovery fast approaching, seems to be making a desperate attempt to circumvent the rights and privacy of others in the hopes of finding a connection between any Wayfarer party or their council and some of the negative online reports. She has resorted to throwing metaphorical spaghetti at the wall and seeing what sticks. Factual background. I am number 10 of 20 independent online commentators who lawfully comment on court filings and publicly available material related to high-profile litigation. I do not have any affiliation with the defendants counsel, or anyone related to defendants in this matter. On the 18th of July, I received notification from another subpoenaed ex-user to say that they believed that I was on the subpoena, and that my identifying information, including names, emails, addresses, IP logs, payment data, and other personal information was being sought. Not all of us have had a copy of the actual subpoena, including myself, and I have concerns that many people affected will not have the chance to defend their rights against this subpoena due to not receiving notification. The subpoena issued by Plaintiff's Counsel Ezra Hudson requests the following from Mexico. 1. Names, addresses, email accounts, and phone numbers, including backups. Any information plaintiff wishes to collect regarding Wayfarer and communications with the media should be requested directly from Wayfarer instead of by searching through information obtained from the data controllers of randomly selected accounts on social media that may have made negative remarks about Ms. Lively. 2. In IP addresses, login histories, and geolocation data. Plaintiff has not explained, nor is it readily apparent, why my location has any bearing on this litigation. I reside in the United Kingdom, thousands of miles away from any of the parties, which should be the sum totality of the relevance of my location. Plaintiff has further not explained why they want this information going back to May 2024, when I did not begin speaking about this topic until January 2025. Following the New York Times article, "We Can Bury Anyone Inside the Hollywood Smear Machine" was released. Prior to this, I had knowledge of Justin Baldoni through his acting roles. I was not aware of any Wayfarer party or their counsel. I was only aware of Miss Lively as the wife of Brian Reynolds, not for any of her own accomplishments. Furthermore, Miss Lively herself makes a compelling argument that I have a constitutional right to privacy regarding my financial information. In her response to the Wayfarers party's motion to compel her to disclose her own financial information in this litigation, which she elected to initiate and seek damages, she states, "This argument falls woefully short of overcoming the general rule against seeking party assets and financial information, and Miss Lively's constitutional right to privacy of the same." Miss Lively appears to recognise the basic elements of privacy rights that individuals are entitled to, despite her attempts to pierce mine and several others. X account information, and including payment sources. No third party has access to add additional money to an X creator's account until a few days before the X Corp subpoena was noticed. I was not monetized on any platform, and I am not monetized on X or any other platform. 4. Bank account and credit card information. I'm interested to know what could possibly be gained by accessing my bank account and credit card information. Plaintiff claims to be looking for signs that as a content creator, I'm allegedly being paid by someone outside of AdSense on my YouTube account to create my content favorably to Wayfarer or negatively to Miss Lively and Mr. Reynolds. This request for my financial records is overwhelmingly invasive. I restate that any information plaintiff wishes to collect regarding Wayfarer and communications or payments with media and social media should be requested directly from Wayfarer, instead of chasing down every account that may have made negative remarks about Miss Lively and demanding I show my private financial information along with anyone whom I share a bank account with. So, I fail to see why information such as bank numbers would be required for any other purpose than to issue a further subpoena to the financial institutions with whom I conduct my business to obtain fuller financial records, which have no relevance to Miss Lively's claims and are grossly intrusive. Furthermore, this information would be futile to Miss Lively as I'm a British citizen and resident, and a subpoena served on me personally would be unenforceable without going through difficult channels. 5. Backup recovery details, premium services, and account usage history. It is unclear what my backup recovery details or premium services have to do with any part of this litigation. This request needs clarification if the court grants her this invasive subpoena. My given Mr. Reynolds was dismissed as a party on the 9th of June, I'm finding it concerning that he is referenced as a party in this action within the definitions of the subpoena dated the 3rd of July. And again, that's an exhibit I'll show at the end. This seems at odds with the court's order dated 18th of June 2025, and as far as the content creators are aware, Mr. Reynolds is not alleging any untraceable retaliation campaign for raising allegations of sexual harassment. I find this heightens my concerns that this is a fishing expedition intended to cause intimidation and harassment. I have been left with little time to respond before the deadline. Out of abundance of caution, I'm adhering to the date of 31st of July, regardless of the original typo in my name. A legal standard. The Hague Convention on the Taking of Evidence Abroad in Civil or Commercial Matters, which is UK law. The UK GDPR and Data Protection Act 2018, that's the UK law. And Article 8 of the European Convention on Human Rights and the Human Rights Act 1998, again UK law. This is American law. We have Rule 45D3A, Rule 45C2, and then Section 2702B3 of the Stored Communications Act. So the argument, firstly, I'm going to go in UK law. I'm a British citizen and resident, and as such, American courts have no jurisdiction over me or my data. The footnote here is it applies to Rule 45D3A, which I'm making the First Amendment argument on behalf of the American people who are affected by the subpoena. but it does not apply to me because I'm obviously not an American citizen or resident. So I'm not making that argument for myself, and I'm making it for other people. So, to coin a phrase, once a subpoena leaves its jurisdiction, it becomes nothing more than a wish list. My starting point is that in US litigation, it is considerably difficult to obtain documents and testimony from non-parties in the United Kingdom than it is from US citizens. So, I'll start with the Hague Convention and Evidence Proceedings in Other Jurisdictions Act. To be entitled to examine or obtain documents from a non-party in the UK, US litigants must first submit a letter of request, also known as a letter rogatory, to the UK Central Authority, who then forward it on to the Senior Master of the High Court. The request must show that a non-party's evidence is sufficiently relevant to a material issue in the action. The British court must also be satisfied that the party seeking the discovery of the non-party could not obtain the information elsewhere, that it would be unfair to require a party to proceed to trial without this information, and that the non-party discovery will not lead to undue delay or unreasonable expense. Miss Lively's counsel has not followed any of these steps. They have instead chosen to send out a series of fraud and improper subpoenas to tech companies and cross their fingers in the hope that some companies may fall for it. They have effectively abused their subpoena power to create what can only be described as spam subpoenas. The English courts have frequently interpreted the EPOJA to apply to narrow requests and are increasingly denying overly broad requests which could be construed as fishing expeditions. And then we go on to the UK General Data Protection Regulation, which is the GDPR, and the Data Protection Act. The territorial scope of the GDPR would apply, namely because although X-Corp isn't established in the UK, it offers goods or services to people in the UK or monitors the behaviour of people in the UK. The UK GDPR applies to processing related to that targeting activity. X-Corp is certified under the UK extension to the EU to US Data Privacy Framework. Their certification became active on the 4th of April 2024 and will be valid until 3rd of April 2026. And I do put a link to that certification, to X's certification to this framework. Under DPF, the US company must have a lawful basis for processing and disclosing the data, such as consent, legal obligation, or legitimate interest. Furthermore, disclosure in response to a US subpoena may not qualify unless it aligns with UK GDPR exceptions, or is approved by a UK court. As a US entity, X-Corp cannot simply release UK citizen data to third parties, including courts or law enforcement, without ensuring GDPR compliance. Under the DPA and the UK GDPR, personal data can only be disclosed if there is a lawful basis, such as a consent, legal obligation under UK law, or vital interest. A US subpoena does not qualify as a lawful basis unless it is validated by a UK court, which Blake Lively's has not been. Article 8 of the European Convention on Human Rights and Human Rights Act. So Article 8 guarantees the right to respect for private and family life, home and correspondence. When a US subpoena seeks data about a UK citizen, especially from a UK-based entity or under UK jurisdiction, Article 8 becomes a key barrier unless the request is lawful, necessary, and proportionate. It's processed through UK legal channels such as the Hague Evidence Convention. The UK court determines that the disclosure does not violate privacy rights. A UK company or data processor may refuse to comply with a US subpoena if doing so would breach Article 8 protections. Even if the data is held by a US company, UK GDPR and the Data Protection Act still apply where data concerns UK citizens, which I am. So I'm going to go over US law now, because obviously this is a US subpoena and it's subject to Rule 45 of the Federal Rules of Civil Procedure. Most of these issues have already been addressed throughout this motion under the UK law, but for the sake of completeness, I will address the effect of US law on them. I've engaged in lawful commentary on a high-profile lawsuit, a matter of public concern. I'm not a party to the case and have no affiliation with any party. Plaintiffs have not provided evidence of wrongdoing, much less satisfied the burden for disclosure, merely because I express a perspective disfavored by the plaintiff. Disclosure in this context would chill lawful expression. Rule 45D3A. The demand for extensive personal data, including banking information and geolocation, goes far beyond what is relevant or necessary. It has the potential for inclusion of private data of not only non-parties, but also the spouses and family members of non-parties who are included in joint bank accounts, live at the same address, share the same phone number, email address, credit card, social media account, or use the same IP address. I'm not a party to this action and should not be forced to bear the burden of compliance, much less my loved ones. Plaintiff cannot offer one single piece of evidence to explain or support these requests. The only reason I'm being pursued in this matter is because I do not speak favourably about Miss Lively, her husband, or her legal team that has been seen as abrasive, mean-spirited, and unprofessionally careless of any party's personal information, including their own clients. And the footnote there will take the judge to the docket, and it references emails that were sent 2 days apart. And they had the location of Miss Lively's planned deposition for the 17th of July. And on the first email thread, the location was not redacted, but on the second, it was. So I cite that as evidence that, well, they can't even look after their own clients' personal information, especially, and that one concerned safety as well. That's what they argued. So I don't want them having my data. Rule 45C2. In accordance with the Uniform Interstate Deposition and Discovery Act and the Federal Rules of Civil Procedure, 45C2, subpoenas served outside of 100 miles of the issuing court must be issued in the court district of the entity being served. X-Corp is based in Texas and Ireland, and I've since had the subpoena that she actually served them in Nevada, so I didn't have this information when I wrote this. So I give in the footnote there, I do actually say roughly how many miles apart New York is from Texas, nearly 1,800, and Ireland, it's 3,000. I live in the UK, and I put another footnote there, I'm nearly 3,500 miles away. It's fair to say that the locations of both X-Corp and myself exceed the limit of 100 miles under the Federal Rules of Civil Procedure by a factor of 18 at minimum. Furthermore, as a UK citizen, X-Corp in Ireland should be the data controller for my account. The plaintiff has served a subpoena for my information to the X-Corp in Texas. Again, I didn't know she'd actually served Nevada. X-Corp's own help center says, that these requests should go to their Texas headquarters. Section 2702B3 of the Stored Communications Act creates an exception based on lawful consent that applies to civil discovery. The SCA authorizes an ECS or RCS provider to divulge the contents of communications when lawful consent has been given to do so. And X-Corp does not have my lawful consent to disclose any of my personal information. And they go through their case law on that, where the judge said no. G. Plaintiff failed to obtain a court order before attempting to unmask anonymous accounts. So now I'm coming out of the law and I'm going over the general kind of, standards here. This one is more for the people who are, again, really anonymized. I have my picture. My name is not my real name, but, here we are. Mr. Lively wants all of our personal information. And I'm saying people don't want to, not just me. So I object to the subpoena to the extent it seeks my information about many anonymous YouTube and X users. Again, I didn't know TikTok had been subpoenaed at this point. Without first obtaining an appropriate court order as required by the First Amendment. I'm not going to go into all of that, but again, it's more case law and citation saying, look, in this case, which is, very similar, the judge said no. While attorneys affiliated with Manat, Phelps, and Phillips may be accustomed to filing sham doe lawsuits, as they have done in this case, to access the entire contents of defendant Jennifer Abel's phone, in which they filed a fabricated complaint with false causes of actions using Mr. Reynolds' shell company, because don't forget he's very recently registered himself as CEO, in order to serve a discreet subpoena to seemingly legitimize information they may already have been in possession of. And in the footnote, I give all there's exhibits like Ryan Reynolds now being the CEO, but also the original ones where they've used a company called LS Incorporation, and they registered the business on behalf of Blake Lively, Ryan Reynolds, and one of the services they offered specifically was fictitious name filings. So all of those are in the exhibit. Once the Van Zandt lawsuit had served its purpose, it was quietly withdrawn without any Wayfarer party or their counsel being aware that it existed. This is not the way to litigate fairly. Every person being served a subpoena has the right to be notified, legally represented and protected, either by counsel in a standard lawsuit or by a presiding judge who has heard the pleadings and determined that the legal necessity of said subpoena in a doe situation, so that does have legal representation to protect their rights. I have concerns that not all content creators will have the chance to defend themselves, since there is no complete list available for whom Ms. Lively has requested this overboard, intrusive information from. I request the court see that all doe-type subpoenas served without court order from the appropriate district court be revoked, and any future subpoenas of this type be properly filed by Ms. Lively, being required to present her prima facie case to the appropriate district court for a court-ordered subpoena to protect the First Amendment rights of everyone involved. This has not been done in my case so far. In accordance with the Uniform Interstate Deposition and Discovery Act and the Federal Rules of Civil Procedure, 45C2, subpoenas served outside of 100 miles of the issuing court must be issued in the district court of the entity being served. So again, I hammer that same point because that's so important. H. Disclosure would cause irreparable harm. I'm concerned about the possibility of myself or my loved ones being exposed to the same harm that came to the Wayfarer parties. Safety and privacy are of the utmost importance. The chilling effect on protected speech and protected privacy due to the concerns that come with private information being exposed is profound. Ms. Lively and her same law firm, Manat, Phelps and Phillips, have already set one dangerous precedent during this lawsuit, namely the Van Zandt sham lawsuit, where Miss Lively obtained the entire basis of her retaliation claims spelled out in the CRD complaint, the New York Times article, and the subsequent lawsuit. Despite the New York standard for filing a Doe lawsuit outlined in Sandal's report, which states a petitioner must demonstrate that it has a meritorious cause of action and that the information sought is material and necessary to the actionable wrong. And basically, in this case, the plaintiff was precluded from compelling Google to provide information because they hadn't offered any evidence of harm that has come from the account holder, which is, same circumstances here. Ms. Lively has not proved anything, not shown a reasonable, probable cause for these subpoenas. It appears there could be no retaliation claims without the ill-gotten information obtained by the Van Zam sham subpoena, which appears to be an abusive process. Now, I do get quite heavy with the words here. Yet this case continues and now baselessly seeks mine and 19 others' private information. Miss Lively must not be allowed to collect such sensitive information to use in a harmful way again. The article, written by former defendant, New York Times, appears to have begun being written months before any judicial proceeding was ever filed in court, and I linked to my own X account the video of me finding that metadata, the October 31st. It also states that the information relied upon came from thousands of pages of emails and texts, which we now know were produced by the Van Zam sham subpoena. Ms. Lively and her law firm cannot be allowed to misuse the courts of New York as a witch hunt against those who speak their opinions about her conduct as a public figure and as a party to a public judicial proceeding. So there's two more footnotes there. At the end of, we now know they were produced by Van Zam subpoena. It's a bit of a message to Jen Abel. I say, that said, I am grateful for the opportunity to assert my rights in this court and challenge this subpoena, seeking access to my personal data, an opportunity that was denied to Jennifer Abel, whose private information was pirated through legal process, including a civil subpoena. And I am quoting her first amended complaint footnote there. And then the second link regarding, Miss Lively cannot be allowed to misuse a court to conduct witch hunts. I've actually put a link there to her appearance with Seth Meyers, where she said, "I see so many women, especially right now, afraid to speak, afraid to share their experiences, and fear is by design. It is what keeps us silent." And I think the sheer irony that I'm being subpoenaed, along with many other people, another 42 people, for creating content where we predominantly talk about our own experiences and criticize her behavior in this. I feel like it's an attempt to silence us. So that's why that link is there. I have never been contacted by any Wayfarer party or counsel. However, I am not going to mislead the court and claim I have never contacted Wayfarer counsel. I have freely disclosed that I have sent information that I believed to be important to some of Wayfarer's counsel via their publicly available email addresses, including the metadata discovery and the video of fellow YouTuber Colonel Kurtz, the amazing Colonel Kurtz, playing an uncovered recording of WME CEO Ari Emanuel admitting that he had terminated Justin Baldoni's contract with WME because of Blake Lively and Ryan Reynolds. And I linked that video. That finally needed to come into court. It just hadn't been presented before, so it's there now. I was never asked to do anything on behalf of any party. I have not been paid by any party, and the communications I did send of my own volition to Wayfarer Council received no response. It remains unclear by what stretch of the imagination Miss Lively believes that I am a part of some secret plot to smear her when I have been open about what I have sent to Wayfarer Council. Furthermore, Miss Lively cannot attempt to obtain those communications from me, as I am under the UK jurisdiction. Miss Lively proclaims herself to be the voice of women, and vowed not to stop speaking for us, while simultaneously causing lasting harm to women after women. I have not engaged in any alleged smear campaign, nor has Miss Lively offered a modicum of evidence to support her belief to the contrary. I should not have to endure this abusive and harassing attempt to violate my privacy rights as well as my right to comment on the public lawsuit. And the reason I use the words abusive and harassing is because that's how Blake Lively described Friedman's subpoena to Taylor Swift. Every phrase, everything in here has been very thought out, and there is a lot of using her own words back against her, and that's deliberate. That's my background is coming into this. I can present a legal argument. Here it is. This is everything you said, and this is why it's so ironic and hypocritical that you're doing this to me. Conclusion. This subpoena fails on multiple grounds. Aside from the obvious jurisdictional defects which Miss Lively cannot overcome, it is breathtakingly overbroad and invasive, putting not only myself as a non-party to this case at risk, but also my loved ones who share bank accounts, credit cards, physical addresses, IP addresses, phone numbers, etc. It is baseless, since there is not one shred of evidence that I am or have ever been paid by any of the Wayfarer parties or their counsel or anyone affiliated with them. The evidence does not exist because it did not happen. This is yet another misstep that will bring even more criticism to her already shattered public image. Relief requested. I respectfully request that the court, 1. Revoke this and all non-party subpoenas served on internet providers, phone providers, and social media and streaming sites such as Google, YouTube, Instagram, TikTok, X, Reddit, etc., that have not been properly presented to a court and had a prima facie showing that led to a court order permitting the subpoena to be served, noting that an out-of-district subpoena must also pass inspection in the district it will ultimately be served in. 2. Quash the subpoena served on X-Corp for movement 10, that's for me, and all others 1 to 20. So I'm starting with quash all 3 subpoenas. And if that doesn't work, then quash the X subpoena. Then the next alternative is quash a subpoena just for me, movement 10, as I am beyond reach, and the subpoena does not adhere to proper protocols for foreign citizens. 4. Alternatively, if you're not going to quash a subpoena, at least let me submit a declaration to confirm that I did not participate in any smear campaign or create content on behalf of any of the Wayfarer parties or their counsel. 5. Because of the spelling mistake, I could foresee Blake Lively possibly going back and correcting that, or even going through the correct channels, the Hague Convention, to subpoena me as a foreign citizen. And I'm asking the court here for a protective order. Please don't let her do that again. She's got no basis. So under Rule 26.5c, I am requesting the court issue a protective order to stop Blake Lively from coming for me again. 6. I'm also asking the court to grant such further relief as the court deems just and proper, including but not limited to sanctions for costs to cover this completely unnecessary and violating subpoena served without court order, cause, or reasonable explanation. It has already consumed days of my time to determine its validity. And here's the exhibit. So this is Exhibit A. This is me doing a search for Kiara Jade 200 with the number 1 missing at the end. And as you can see, it offers one account, mine. So there was no doubt, and I had to satisfy that. I couldn't just ignore it because there was a typo. That's not how the rules work. So there we go. And like I say, they did actually come back and email me and say, yes, it's you. And by the way, don't ignore it. Here's the part of the definitions, and as you can see in blue, it's got Mr. Reynolds shall refer to Ryan Reynolds, who is a party to this action. No, he's not. And here we have this is the incorporation for Van Zandt. Got Ryan Reynolds in pink here. He's now the chief executive officer. And this is the original certificate of incorporation with Celeste Brine of Ellis Incorporation. As you can see there, we originally thought that was Leslie Sloan. It was like the initials for Leslie Sloan, but when I looked deeper into it, I found out it wasn't. It was a person called Lisa Sawyer, who owns Ellis Incorporation Services, and in blue it does say their services include name checks, filings of articles of incorporation, annual corporate minutes, and fictitious business name filings. So there we go. That's all of the stuff I've sent to the court, and yes, it has been served as of now, a few days ago. So it should be on the docket hopefully soon. Anyway, I just wanted to redo that so that people just had that filing and it was a straight run through with hopefully as minimal interruptions as possible. I hope you enjoyed it, and I will obviously keep everyone posted on what happens. Like I say, they have contacted me since I've served this motion on them. Manat have contacted me and asked to arrange a meet and confer. So we'll see what happens there. But thank you very much for listening. Thank you for your support, and I will catch you again really soon. Bye-bye.